Welcome back to the Justice Factor. The Western Cape High Court has ruled that, and I quote, unlike an order or decision of a court, a finding by the public protector is not binding on persons and organs of state, close quote. But he also said the public protector's findings were not recommendations which an organ of state could accept or reject. Deputy Minister of Justice and Constitutional Development, John Jeffery, joins me today to discuss the Nkandla issue and the limits of the public protector's powers. Deputy Minister, welcome to the show. You must be happy with the decision of the ad hoc committee, parliamentary ad hoc committee on Nkandla, because they've essentially come to the decision that actually President Zuma doesn't have to repay back any of the money.
Look, I don't think they've completed their work, and I haven't seen their final report, or I haven't seen any report from them.
But what it does, if the initial reports are true, is that essentially it sidesteps the decision of the public protector, thereby annulling her call that President Zuma must pay back the money.
Look, as I said, I haven't seen the report of the ad hoc committee. That's still got to come before the House.
Do you believe that her powers should be, as I read out, as the Western Cape High Court ruled under Judge Ashton Skeepers?
Yes, very much. I mean, that's what I've been saying all along, that they cannot be binding or enforceable. Remember, the public protector is one person who is conducting an investigation. Mm-hmm. They can't be investigator and judge at the same time. I think the decision was a good one of saying that they can't just be disregarded, they need to be taken into account, they need to be considered. But can you imagine if one person had so much power?
No, but that person doesn't have that much power. That person has the power, as we wrote in our Constitution, to investigate and so forth and forth, and then it also said in Section 182 and to take remedial action.
Yes, but I mean, if one person could take a decision that something must be done, mm-hmm. and that decision was not subject to any appeal. Remember, you can only review the public protector's findings, decisions. Remember, in any other matter where there's a finding that is sought, evidence gets put before a presiding officer, a judge, everybody can see the evidence, can cross-examine it, and then if you don't like that, if you don't agree with that finding, you can take it on appeal to a number of layers. With a public protector, it's an investigation, which is what happens with an ombud, and then a decision is reached which cannot be appealed against.
No, Mr. Mutsoning is appealing the judgment that he must be put back he must be taken out of the job that he was promoted to, and that's a point of recourse for him.
Yes, he's appealing against the Western Cape High Court decision. He's not appealing against the public protector's decision. So there's a difference. Court decisions are appealable. Mm-hmm. The public protector's decisions are not. And they're conducted, or the finding is made after an investigation. So there's nothing wrong with it. Mm-hmm. That's what normally happens with ombuds. Mm-hmm. But you can't, it would be immense power in the hands of one person for those decisions, those findings to be enforceable and binding.
John Jeffery, the Western Cape High Court said, and I quote from the judgment, disregarding the findings and remedial action subverts the public protector's powers under Section 182. Don't you agree with that?
Yes, that makes sense. I mean, you have an ombud, the public protector, as you have other Chapter 9 institutions. Remember, the Human Rights Commission is in the same position. It is making findings, determinations. Those determinations should not just be something that you can ignore. They must be taken into account. So I agree with the judgment in that regard.
And so if we go back to my first question to you, don't you think in the case of the ad hoc committee in Parliament, therefore, that this became a case where the public protector's report is being sidestepped, so that it's, let's take the SIU, let's take the interministerial.
Look, as far as I'm aware, they are considering the public protector's report.
Among others.
Among others. Mm-hmm. There are also other reports. I mean, the irony is that the Special Investigation Unit legislation provides that if a matter is more appropriate to be investigated by the public protector, the SIU should refer it there. And similarly, if there's something that the public protector is investigating that is more appropriate to be handled by the SIU, it should be referred to them. That happened in the past with earlier public protectors. Selby Batwa's investigation into the Independent Broadcasting Authority, he said that a section of the investigation is better done by the SIU. Unfortunately, it's not being followed anymore.
Can I therefore put this question to you, that it looks to me from the outside that you are now interpreting the law and the section that empowers the public protector very narrowly to say she doesn't actually have the powers to do these things merely because it's President Zuma at the heart of the issue.
Absolutely not. We've always said the decisions of the public protector cannot be binding or enforceable. It has nothing to do with who the finding is against. In fact, I would actually turn it around and say that the only reason people are now saying, people, journalists, whatever, are saying that the finding should be binding and enforceable is because of it being against the president.
But no, it looks as if on the outside, from the outside, and I would say to you that actually the unprecedented attacks on the public protector, the questioning of her powers, and the joy with which this judgment by Judge Ashton Skippers was welcomed is essentially because, no, it's President Zuma and let's keep her. So it's no longer even legal, it's political.
No,
it's anyone but Jacob Zuma.
Justice, it is legal. It's an issue of no other ombudsman in the world that I'm aware of has powers to take decisions that are binding and enforceable. So the situation here is as it is elsewhere. Other public protectors, Advocate Batwa particularly, had specifically said that his powers were not enforceable and binding. So it's only something, I would argue, that's come up recently, this issue about them being binding and enforceable, and I would argue it's come up because people like the decision of the public protector in this particular case, and they're pursuing it for a political basis.
But the Western Cape High Court also found that actually you can't ignore these findings unless you can show that they were irrational. Was she irrational in her findings?
No, I don't think it was saying that. I think my recollection, I don't have the judgment in front of me, was that the decisions of the public protector and findings must be taken into account, and that there cannot be irrationality on the part of the person to whom the recommendations are made, that they can't irrationally reject the findings. It's not a question of whether the findings themselves are irrational, it's the person taking the decision can't irrationally reject them.
Isn't it irrational, therefore, to say that actually the public protector has found this, but I'm going to refer this to the SIU, to an interministerial task team, when a body set up by your own constitution, your own progressive state, build this into its constitution, and you're now saying, no, we're going to find other ways of putting more into the poll.
Look, it's also your constitution.
Yes, it's my constitution, right, that's why I love it so much.
Okay, but I think that the SIU and the public protector have different powers and do different things. For example, the SIU has got the power to pursue people to recover money. The public protector doesn't have that. The SIU has the power to approach the courts to have leases and contracts cancelled. The public protector doesn't have that. Look, I mean, that's another body, but there are different bodies performing different functions.
Do you think that the public protector, as the SACP says, has overstepped its mandate?
I think that it was unfortunate that the public protector felt, and I think still feels, that she has powers, that her recommendations and her findings and her decisions are binding and enforceable. But that's why we have courts. So disagreement is something good, something positive in a constitutional democracy.
What she said was that the judge may have said that they are not binding or enforceable, but there must be the pushback must be a rational one.
Yes.
And therefore,
yes.
In the case of the Nkandla issue, for example, I find in myself, I find that the decision to keep on fighting back is not a rational one. Clearly, if you have 246 million rand spent on your house, allegedly on security upgrades, there should be some way that you can take moral responsibility, political responsibility for all those things and not say, no, I didn't know.
Look, I think, have you read the ad hoc committee's report as yet?
I haven't.
I haven't either.
But the reports indicate,
yes.
the reports indicate without doubt that President Zuma has been absolved. However, officials in the Department of Public Works are going to be followed up.
Look, I haven't unfortunately read the report either, so I wouldn't want to comment on it until I've had a chance of seeing it.
Don't you think it's in our DNA to say this constitution gave us a body, this body recommends this, and therefore it's we should, all of us, as the African National Congress, as the people of South Africa, take some moral responsibility, and the president should take some moral responsibility for what happened at Nkandla.
Look, the Nkandla issue is still under discussion and under investigation by Parliament. So I really wouldn't want to prejudge things on that matter.
But you still believe that the public protector her recommendations are not binding on enforcement?
Well, that is the view of the Western Cape High Court. As I said, that is a situation with other ombuds across the world. And imagine if one person had the power to conduct a quick investigation and then make a decision that you couldn't appeal against.
No, you can appeal against it on the basis that you believe that she was irrational or that you can...
Well, you can take her on review, and review would be about the procedure followed and whether she was irrational.
You said
whether she was...
you can say that it was too quick, she can't have reached these conclusions, this is a political stitch-up.
Well, it depends on the process that was followed. But I mean, we don't have any one person in our... We have checks and balances in our constitutional dispensation. We don't have one person with the power to take decisions like that without allowing other people the opportunity to make their input and then to appeal against it.
Deputy Minister, that's all we have time for. Thanks so much.
Thanks very much.
After the break, our big winner and the loser of the week.